Hey, good afternoon, everyone. An introduction to law. We're going to go over Chapter 12. I believe it's Chapter 12 in property law. We'll go over some of the key provisions of the chapter, kind of summarize what I think is important within it. Many of you are legal studies majors or paralegal majors at the Mount, and you're going to take a specific class called real estate law that's going to dive deeper into these provisions. But it's a nice summary. It's actually a nice way of review if you've already taken real estate law. And some of these courses or topics, I should say, from property law in this chapter will overlap with estate planning, overlap with family law, and clearly overlap with real estate law, because that's what real estate law is all about, is property. But I was just going through the chapter myself, thinking what are the salient points, what are the high points that I really want to stress, and well, all of them seem important to me, but I'm going to try to go through them in a fairly rapid fashion, stressing what I think is important, things that you want to know for the exams or quizzes, and also just things you want to know as a practitioner, as a paralegal, potentially an attorney later on, or just as a citizen, because these topics will be important to you when you're going to become an owner of real estate or want to work in the area of the real estate field in some fashion as a salesperson or a broker. You don't know where you might end up, and these kinds of concepts should be known by all of us, I believe. The chapter starts off with what is real property. We think of real property as land and things that are so permanently affixed or adapted to its use that really become part and parcel of it. And what I mean by that is something that was once considered to be personal property, movable, identifiable objects, have become so attached to the land or the buildings on there that they can't easily be moved, and there was an expectation they'd be adopted for the use of the property such that they couldn't be removed without expense, cost, difficulty, or the like. And that's called fixture analysis. We actually do that quite a bit in real estate. Somebody selling piece of land with a home on it, we know the home is going to be sold with the real estate because it's so permanently affixed and adapted to its use that the expectation is going to be there. But what about the things within the home? Like, say there is a washing machine that washes dishes. If it's hardwired and hard plumbed and it is also designed to match the cabinetry within the kitchen, there's a strong argument that that's now a fixture. It's become part and part of the real estate because it's adapted to the functional use of the home, can't be removed without great cost or expense, and it would create a bit of an eyesore if removed because it was designed to be matching of the counter space within the home. The practical lesson I want you to get out of the analysis of what is real estate in terms of a fixture is, when in doubt, always be in doubt, write it in the contract. So if you're the seller and you want to take things with you, you could actually take a fixture with you if you were to clearly articulate that in the written contract, that upon sale, certain things are going to be removed. Like maybe there's a bar in the basement that was built in that can't be removed unless it's disassembled, and it's got hard plumbing in it, it's got hard electrical wiring in it. And to create any kind of confusion, maybe you built it or your family member built it and you want to take it with you out of sentimental reason or just because you love the thing, make sure you're clear and articulate of what stays and what goes. And that's the same for the buyer. Buyer comes in expecting certain things to be in the home, and they may be surprised when they get to the home and there's a chandelier missing. They thought that was going to be sold with the house. It was hardwired into the electrical fixture. It was very large and very heavy, and it lit the living room area. And now once removed, there's no lighting there and has to be replaced. And there's exposed wires, maybe safely exposed, meaning there's conduit on it and the wire nuts and things like that, so it's safe. But there was an expectation that you had that the chandelier was going to stay. But maybe it's been in that family for generations, and they brought it over from Europe, and they wanted to take it with them. To avoid having to go into the analysis of whether something has become a fixture, the size, how attached is it, how fundamentally related to the functionality of the real estate is it, is very debatable. And there's trials over that very issue. If you go into law school, you study real estate class here at the Mount, you spend time just doing fixture analysis, and there's a lot of fun little exercises you go through. It's not fun when you're actually practicing law and there's an issue where somebody bought a home and there's things that are removed. I had a friend bought a house and had a garage in it, and there's a lift in it, like a mechanic's lift that you can lift the car up and you can park another one underneath it. I guess it's both for mechanical purposes, but also for storage. A person who's into car collecting, they can fit multiple cars in one garage because it had a very high ceiling and it had this lift system in there. And I remember my friend saying he was really excited about it. I said, well, let's make sure that the seller is selling it with the lift. And sure enough, they were. But to avoid debate, if all of a sudden he showed up after closing and the lift is missing, there might have been an argument that lift is personal property and not necessarily a fixture just because of its size, because maybe it's fairly easy to unplug and unbolt and remove it without damaging the house in any way with very little expense. There'd be an argument on the seller's behalf that that's actually was personal property and it remained personal property. It didn't turn into what we call a fixture. And what is a fixture? Something that was once personal property that's become so attached to fix or adapted to the use of buildings on real estate that it becomes part and parcel of it. And I don't always know the answer. It's called fixture analysis. We go through that whole kind of litany of elements to determine whether or not something is in fact become identified as a fixture and therefore real estate. So the different kinds of ways you can own real estate, the most common way when you think you own it absolutely is actually called fee simple absolute. It's a type of freehold estate. No one talks like that. We just call it fee simple or fee simple absolute. It's the purest form of owning real estate. You own it individually and you owned it against the entire world. That doesn't mean the government can't come in and take it potentially for taxes, or maybe you have a mortgage on it, you borrowed money to buy it. You actually still own the property, but it's subject to the lien of the bank. But when we hear about fee simple, that's the purest form of ownership. The next one down is called a life estate. In fact, my mother has a life estate in her home. And the reason why she has that is it's a tool that people often use in estate planning. Or say, for example, if I won a ton of money in a lottery. In fact, I just played the lottery on the way home from court today. I bought a lottery ticket and I win millions and millions and millions of dollars. I might want to buy my brother a house, but I'm concerned that my brother's a bit spendthrift. He's improvident with his money. He's not good at planning. If he owned that house outright, he might go and sell it, blow the money doing something stupid, or he might mortgage the property, take more money out in equity on it, and basically not pay those bills and lose it to foreclosure. Well, because I love my brother and I care a great deal about him. I'm just using this hypothetically. He's not this bad of a guy. He's not this reckless of money. But I can buy him a really, really beautiful home and give him a life estate in it. It's his property. He owns it for his life, and it's measured upon his life. Upon his death, we make something called the remainder interest. Maybe it'll go to his daughters, my nieces, or maybe it'll go back to me. And you can have it any way you want. When it goes back to me, if I was the grantor and gave it to him, we call that a remainder of return. It can be a springing interest to a third party as well. So is it going to revert, called the reverter interest, or is it going to be passed on to a third party like his daughters or somebody else? These tools are very, very beneficial in estate planning. Like for my mother and father, for example, as they got much older, they were concerned about if they ever had to go to nursing homes and things like that. They wanted to make sure the property went to my brother and my sister and I without any fear of potentially having a Medicare or Medicaid lien on the property. And so it was paid off. They completely owned it. So they actually transferred the property to my brother, sister, and I as remainders, and they reserved a life estate for themselves. So they are life tenants of that property. They can use it in any way, shape they want. They don't have to stay there. They could rent it out to somebody else. They could, in fact, they could sell their life estate. I don't know who'd buy it because it'd be measured on their life. So you buy it from, now my father has passed away. It's 10 years now. But my mother's still alive. My mother's alive. She's living it with a life estate. She could sell it to anybody else. My mother's going to be 90 this year. Anybody that looks at her is going to say, I'm taking a bit of a risk. If I buy the life estate from you, you could die tomorrow in a car accident, or you could die from natural causes very, very soon. So it doesn't have a lot of value. In fact, no banks will usually lend money on someone's life estate. It's more of a estate planning tool for families to do things like that, of that nature. And I always think, I have a good friend of mine has I think it's a beautiful old farm. He's land wealthy, meaning the property does have a significant amount of value. And he says he wants to sell it and move to a different area. Well, deep down inside, I don't think he wants to sell it all. He just doesn't feel like he can afford to really maintain it because the taxes are very high in real estate and things of that nature. So I always thought, boy, it'd be great. If I won, I'd buy it off him, but I'd reserve a life estate for him so he could use it and have ultimate control. I can't interfere with him. He just simply can't commit waste, basically ruin the property, but he basically owns it for the remainder of his life. That way he keeps the thing he loves, but I would pay him the fair market value of it today, just so he'd have cash available. So that's called a life estate. You can also have a estate for a term of years. You give somebody some property for 5 years, 10 years, things of that. Leaseholds are a type of estates as well. But a life estate, and you can be really creative. I don't want to get too deep in this, but you can be really creative. I could give my brother a life estate and a piece of property for my mother's life. So my brother gets to use and occupy it, but the measuring rod, the tool of the life estate, is actually measured by my mother. So maybe I promised my mother I'd take care of my brother while she was alive. Upon her death, forget about it. You can be very creative with life estates like that. You can do all kinds of very, very creative tools. And what's nice about it is, this sounds terrible, but the nice mechanism, if you will, involved in a life estate is upon my mother's death, we don't have to probate that estate real estate. It automatically vests it's already vested, but it automatically becomes fee simple absolute. And my brother, sister, and I, we own it as tenants in common. I'll get to that in a second, the different forms of multiple ownership. But that's a life estate, fee simple, freeholds, other estates. Oh, fee simple, divisible. That's a very interesting thing. So going back to my buddy who's got that beautiful farm, he keeps thinking about selling it. And I know psychologically he doesn't want to ever see it developed into homes or anything else. He'd love to see it as, say, agriculture. He could actually sell it to a third party on a fee simple, on a condition subsequent, or fee simple determinable. They're very similar. One's automatic. The other, you have to take a court action to actually resolve the title. Don't worry about that. Here's the basic conception. My friend passes the property with a deed to this third party on a fee simple determinable, saying, I give it to you in fee simple so long as it stays in agricultural use and it's not developed beyond the one single family home that's on the property, and it must not be developed in any other way, shape, or form other than those consistent with consistent agricultural practices, conducted in the year 2023 or something like that. That gives the buyer fee simple absolute, but subject to conditions. They have to use it in that fashion, or they're subject of losing it and it will be a reverter interest back into my friend. That's often done with people who donate land to, I don't know the different, I should know them because I'm involved with them, or, used to donate a lot to these different, Sierra Club, there's different open space committees all over the state of Massachusetts, for example, that often take donations of land, and the donations often stipulate that this is contingent upon a fee simple determinable that the land stay in open space to be used for, just laying fallow. People maybe can hike out and access to it, but it can't be developed into, gas stations and malls and schools or anything like that. It's got to stay like that. And if it isn't, it violates the terms and it reverts back to the owner, or it doesn't have to revert back. It could be a springing interest and go to some third party. So my friend gives it to me, sells it to me for fair market value, provided I use it as a farm. But if I fail to use it as a farm, then it gets donated to the Mass Audubon Society for a bird sanctuary. You can be very creative with fee simple determinables. And the only difference between that and a fee simple condition subsequent is the grantor has the option. They don't necessarily have to take it back. They can say, well, Jim's not using it as meaning me, I'm not using it as an agricultural purpose, but I developed I don't know what I developed there. I opened up a chemistry plant, but the chemistry plant's designed to make drugs to help people fight all kinds of insidious diseases that plague humankind. If my friend or my friend's estate learn that I do that on a fee simple, on a subsequent condition subsequent, they could decide not to exercise the right to reverter for failure to use it as it was. That's the only difference between a fee simple determinable and a fee simple and a condition subsequent. It's really like a law school technical exam. Don't worry about it. I'm just saying that you can convey real estate with mechanisms to basically bind people and owners to refrain from developing or using it in a certain way or not using it in a certain way. Pretty powerful tool. And for some reason, it comes up here in this part of the chapter about elected term. Might as well talk about the different kinds of multiple ownerships. The first one is between, it's not really first for importance, but the one I want to deal with first is husbands and wives. So my husbands and wives can own property, or spouses, I should say. Spouses can own property in multiple forms, but the most beneficial, usually legally, is something called tenancy by the entirety. And what that means is because they are recognized as a validly married couple, the married couple will own the property in this mechanism, thereby, upon one spouse dying, the other spouse automatically becomes the owner without going through any kind of probate process. It's an automatic tool. There's no taxation between marital spouses' inheritance, so that's also a nice benefit. What's also beneficial about owning property by tenancy by the entirety is that if my spouse goes out and drives the car negligently and she injures a bunch of people very, very seriously, she could be sued, and she could be sued for her assets. But one of them that can't be attached would be real estate owned by tenancy by the entirety, because in order for our interest becomes one, and the action of the negligence had to be somehow borne by me as well. So it protects real estate assets from potential claims from one of the spouses committing torts or owing money in a contract or any other kind of liability. It's a bit of a shield by owning real estate by tenancy entirety. And obviously the survivorship aspect's a very, very popular tool, that if one spouse should pass away, the other one automatically owns it. Now, some people think like, well, they get married and maybe the wife already owns the house, the husband moves in, they're in love, they get married, and they never convert the deed, and the deed's only in the wife's name. Now, upon that wife dying, the husband has interest in that house as an heir at law. And so even if my wife put in her will that I got nothing out of that real estate that was owned, it's all to go to her kids from a previous marriage, I'd actually have a right to take an elective share, which is a forced share of 1/3 of the value of that home. And in most states, including Massachusetts, there's actually a provision where the spouse can take a life estate for a period of time and remain occupant of the main marital home. So there's a lot of tools there. But tenancy by the entirety, one of the arguments for gays and lesbians in Massachusetts when they fought in the Goodridge case to seek the right to marriage was the argument that they couldn't get that same benefit as other married couples could, and that's the benefit of owning real estate by tenancy by the entirety. One that's somewhat similar, but it doesn't give you the same protection for liability, also for sales. So if my wife and I own property by tenancy by the entirety, she can't go encumber the real estate without my consent, and I can't do it to her. I can't go and kick a mortgage on it and get some money for scratch tickets. I can't do it. It has to be a enterprise that's entered into together, and so it protects the asset from basically, a scoundrel of a spouse doing something inappropriate. The next one down, which is very related, is called a joint tenancy. You don't have to be married, and it can be more than two people. Obviously, spouses, you can only have, two people involved, being a married couple. But my brother and sister and I, for example, own real estate by a joint tenancy. What that allows us to do is that upon the death of any one of us, the other survivors automatically own the property without going through probate. So it's a nice tool for family planning like that. My father had a little bit of a shack in the woods in a town called Wales, Massachusetts, and we still have it to this day. And my brother and sister and I decided to put it in a joint tenancy. That's before any of us were married and had kids. I'm just grabbing my coffee. We never had a chance to change that in our lifetime, so that's how we still own it to this day. My brother croaks. My sister and I will own it. My sister croaks after my brother. I own it alone and 100%. We're pretty close, so we never got around to changing it because now we all have kids and things like that. And so maybe we want our kids to have certain interests in it. We should probably change it, but we trust each other, and I think we'll all do the right thing in the end. But joint tenancy is a very powerful tool because it's the right of survivorship. Unlike a tenancy by the entirety, any one of us, my brother, my sister, myself, can go out and get a mortgage on our interest, or we can sell our interest to a third party, which can be very disturbing. My brother and sister could wake up tomorrow and learn that I sold my 1/3 joint interest in the whole. It's not 1/3, like say there's 3 acres. I don't own 1 acre. I own 1/3 of all 3 acres. It's like rays of light coming down. It's a non-dividable portion of the land. So it's not like I own this 1/3, so therefore I own this 1 acre over in the corner. My sister owns the middle 1/3 acre, and then my brother owns the last 1/3, which is the last acre over on the left side. It doesn't work like that. We all own a 1/3 undivided interest in the whole. So if I sell my interest and I sell it to Joe Smith, my brother and sister and I'd be out. My brother and sister would own it. They'd be joint tenants with a tenant in common now, because the new owner can't be a joint tenant. In order for everyone to be joint tenants together, they must receive at the same time. And that's one of the things called the commonalities of joint tenancy. It must be the same exact interest. So if you have 3 people, all 3 own 1/3 of an undivided interest. 4 people all own 1/4 of an undivided interest. It has to be equal proportions. It has to be coming into the same time through the same instrument of transfer. And that's an important concept to remember. But it's the main thing I want you to get out of the tool for joint tenancy is the right of survivorship, but also you don't get the protection. So my brother goes out and he's going golfing and he's negligent and kills somebody with a golf ball. He gets sued. Could his 1/3 undivided interest in the whole be attached and potentially sold at a sale to just to compensate the person in a civil lawsuit? Yeah, it can. So that doesn't give you the same protection. So tenancy by entirety, now joint tenancy. And then the one by its very name kind of gives it away, tenancy in common. There it can be an unequal share. So my brother and sister, actually some of the same land in that same area. We picked up some other land from neighbors over years. And some of those lots we owe as tenants in the common. We happen to own them equally, 1/3, 1/3, and 1/3 interest. But if we wanted to, say my brother was down and out and didn't have any money, and we wanted him to still share in the ownership, my sister could say, I own half, Jim, meaning me, I own 1/3, and my brother owns the other remaining interest. I shouldn't have done the math like that. I should say, let's say there's 4 of us. My sister owns half. I own, another 40%. My brother owns 10%. You can do unequal shares in a tenancy in common. Also, the individual tenants that are in common can share or can sell their individual interests without consent of the others. Unless you have a tenancy agreement, you can always have a contractual agreement to bind you into not being able to sell unless to the other owners first or something, right of first refusal. You probably heard that term before. I'm getting pretty deep. I know there's a lot of stuff here, but tenants in common are just multiple owners of the same real estate. They also own an undivided share. So even if you owned 1/10 the property, you have a right to access all the land and all the fixtures and and buildings thereon. You just have a 10th interest. And that sometimes troubles people if they own a majority of the interest in the land, because you can't deny them the use of the whole. They just have a lesser interest. And that relates to things like contribution. Like say the house burns down on the property and there's a decision to rebuild the house. How much do we have to contribute? You contribute the amount of your proportional ownership. So if my sister owned half, she'd be responsible for 50% of contribution for repairs, maintenance, and things like that. And if I own the other 40%, I'd have to pay that. And my brother 10% would have to pay that. And the same as if we had real estate on there now, and say we were renting it out and we were getting $3,000 a month in rent from the property. We would divide that based upon the income, based upon the proportional interest that we own as tenants in common. Most real estate, and when in doubt, when it's not clear on the conveyance, which we look to the deed or the will if it's inherited property, there's not always a deed to property. Sometimes somebody owns a property and it's definitely clear, and we have to do an estate plan to figure, a retroactive estate assessment to figure out who owns property. It may not necessarily be a deed. But when you figure out who owns it, if there's ambivalence and there's confusion over multiple people that clearly own the property, the law will presume it's a tenancy in common, equal shares tenancy in common. And that's a lot of information I'm throwing at you, but the book is pretty good. I talked about the 4th share of a spouse upon death, right of survivorship. Yeah, each tenant, and these are the 4 unities, each tenant must have received his interest of the property at the same time. It must be from the same source. Each tenant must have identical rights. So there, if it's a joint tenancy, if there's 4 of us, each one has a quarter. If there's 10 of us, each one has a 10th of an undivided interest in the whole. And each party must have an undivided, that's the interest. That's called unity of possession. Those are the 4 elements that are required. Tenancy by entirety, you have to be a married couple. That's it. Now, a lot of people nowadays, they date or whatever before they marry. They sometimes buy their house. They know they're going to get married, but they cohabitate for a few years and they're in love and they're going to get married down the road. But now's the time because the market's right or something and they decide to buy a house. They can't own it by a tenancy in entirety at that point. They probably should own it as a joint tenancy with right of survivorship, equal shares, but they're just a dating couple right now. They get married. What should they do after they get married? To get that additional protection of not being sued by any individual one act, and also protecting you from any one of the spouses bringing encumbrances on the property, they can deed it back to themselves as Jane and Joe Smith as joint tenants. Now deed to Jane and Joe Smith, a married couple. Well, their names might have been different before. As tenancy by the entirety, just to change the nature of how they own the property. I've done a few of those before. Air and surface rights, I'm not going to test you on that, but it's interesting that technically when you own property, you own to the heavens above you and to the center of the earth below. But there's always restrictions potentially in how far you can dig, because there are actually dig permits, believe it or not, even to put trenches in for conduit or wiring or things like that, or any kind of building permit. And the same with how high you can potentially build is usually zoned in a certain area. So just because you technically may own to the heavens above and to the center of the earth below, there are restrictions on how you may actually be able to access that stuff. And That's kind of a common sense thing. Now, the easement appurtenant to and the easement in gross, I'm not going to test you on the difference between the two, but an easement appurtenant is the most classic. There's lot A, over here in the corner, but over to here next to it, they were once one body of property, they were subdivided, and now the road's over here. To get to that first property, there was an easement created. The easement passes through the servient estate because it serves the dominant estate, the one that ultimately gets access from the easement. You don't actually own the land on an easement. A lot of people think, oh, I own this easement. Well, you do own the easement, but that doesn't mean you own the land. You own a right to use it. And you can prescribe the easements for time, place, and manner, that, no vehicles go over the easement, only through foot traffic, or no tractor trailer. You can really create what we call restrictive rules in the easements, as well as proscriptive, telling you what you can do and what you cannot do in easements. And sometimes the easements are implied in law. Like if I had 2 tracts of land or 1 tract of land, I decided to just divide it between 2. And if I didn't put an easement in, the land to the rear would become landlocked. Sometimes the law will say there was an easement by necessity or an easement by implication, because no one would ever purposely split land to leave it unaccessible. So those are kind of easements come up quite a bit in law. And here's so you're buying the property and no one mentions the easement that's traveling through the other lot, so you can get to your, basically it's a driveway through the other lot to get onto the lot you just bought. And no one mentioned anything in the deed about an easement. You don't want to have this debate in court, but if you were to have the debate in court, you can say that it was obvious, open and notorious, and it was used previously, and therefore it's an easement appurtenant. If the easement's appurtenant, it automatically transfers with that dominant estate, even if it's not listed in the deed. But you don't want that debate. Always list the easement. And one of the things you do when you buy property is you always have something called a tape survey done, and you always have clarity on how the access is, and you want it written down, if you're the buyer, that you have that easement rights, and you want it unrestricted. You don't want it to be just for foot. How are you going to build a house on a big, you bought 10 acres and you have an easement, but you can only pass through it on foot? It would be a horror show. You want it clearly articulated that it's basically an unrestricted easement. If you're the buyer, if you're the seller, you might want to put restrictions on it. It's an easement for one person or one home residential dwelling, and because you're fearful that the 10 acres will be divided into a bunch of apartment complexes and condos, and now that driveway that goes through your servient estate might be traveled in such a way to really make it burdensome and noxious, if you will, to have all that kind of traffic going through your land. So you want to be very, very clear on the nature of the easement that's given to you. Buyers and sellers' rights, all the different things. And it has a nice checklist in the book, the different things, the documents associated, the purchase and sale agreement. What are you purchasing? What is the seller selling? How much is involved? What's actually going with the sale? What's not? The mortgage and financing. A lot of people can't buy. You're going to buy a $500,000 house. Most people can't say, well, let me cut you a check. They want to say that I'll buy the house contingent upon me being able to get financing at 8% interest per year with 10% down or 20% down or whatever it is. That way, if it falls through, meaning I can't get the financing, I won't lose my deposit or the liquidated damages, or it won't be subject to penalty for failure to go forward because it was a contingency contract on financing. Most of them have that. When you go out and buy a home, usually if you have a realtor or a decent attorney, they're going to tell you to put these contingencies on there. As a buyer and as a seller, you might not want to deal with somebody that has to get financing because it might slow down the transaction. The transaction may fall through, where you're much more assured to be able to go forward if someone can come in and say, I can do this with cash, meaning I have the money available right now from the sale of my other home, or you're just simply wealthy, or you have private funds available to purchase the home. And that's called a mortgage. It's a loan, but the mortgage which gives with security, because if you don't pay your loan back, the lender, the mortgagee, the bankie, they can come and take the home if you don't pay in a reasonable period of time. So the mortgage is really the security interest. It's the loan document that is the contractual obligation to pay back the money. And the deed, you might as well treat it as if you need a deed. What the deed does is it shows evidence of title passing from the owner to you. And one of the things we often do in a real estate transaction is we make sure the seller he and she, or both, or one, or whoever they are actually the owner of the real estate, and there's no encumbrances on it. And I've had this happen before. Someone says, "Oh, I want to sell my house." I said, "Great," and then I'll just go down and check real quick. Now I don't even go anywhere. I do it right online. I say, "Wait, it says you own it with so and so." He goes, "Oh yeah, with my brother. He's a real deadbeat. He's had nothing to do with it for the past 15 years. I paid the taxes on it, maintained that home. He's a lost cause." I'm like, "Well, he might be a lost cause, but he is one of the legal owners with you. And without getting his assent in some way, we're going to have problems giving good title to the buyer." And the seller is usually not as concerned about making sure there's good title passing, but the buyer certainly is. And the lender is going to, because they're going to potentially foreclose on this property, they want what's known as a title rundown, and we call that an abstract. People go back, sometimes attorneys, there's private companies, often they're paralegals, will actually go to the registry. Often, most of it's done on the computer, but they'll go back, usually 40 years in Massachusetts is long enough, and they'll see that the current owner has valid fee simple that they can pass on to the buyer without any encumbrances other than things like maybe some municipal, lien that are currently outstanding that the buyer is willing to become responsible for or pay off at the time of closing, where we actually consummate the deal and paperwork's exchanged. So a good deed rundown, title search can sometimes show some real errors and omissions, and oftentimes they can be remedied. It might take a little longer to consummate the real estate transaction, but it's like anything else. Is somebody's selling something, I want to make sure I'm getting it, free and clear, or if I'm getting it with some kind of encumbrance, I at least know about the encumbrance ahead of time. There's so many governmental forms. Yeah, I know I have a very new phone, so I don't know how to do the ringtone, and it's Twilight Zone, I think, ringtone, and it's my partner. He just had a jury trial. He's calling to tell the verdict, but I'm almost done with this video, I hope. So there's government forms that are required because there's disclosure about lead paint. There's also other forms, like if you're in Massachusetts, this is, I don't know what it is like in every other state, but Massachusetts has Title V requirements. If you have private well and sewer, you want to make sure it's potable water and the water comes out safe out of the well, and that the septic system is functional and appropriate, and the bank won't let you buy if it has a dysfunctional, usually won't let you buy because they don't want to foreclose on a home that doesn't have appropriate sanitary fields and things of that nature. Inspections, and this is a big one, and I've had my own personal experience, not as a lawyer, but just bought a house one time, and my dad was a plumber and he was into buildings and knew about stuff, and he said, you don't want to buy a pig in a poke, you want to make sure what you're buying has structural integrity and things like that. So you always put in the sale contract that you're buying the house subject to an inspection, and if there's more than $2,500 of repairs, either the seller has to make repairs of those, or we have to renegotiate the contract. The buyer has a right to walk away. And you'd be surprised that if you have a really good inspection done, you might find out that there's major flaws to the chimney and it's pulling away from the house. The one I had was they were inspecting it and they saw that the chimney had no flues in it. I guess it was supposed to be 3 channels where gases would come up, one from the boiler and 2 from the 2 different fireplaces in their home. And they were all shared. They had rotted out over the years or something like that. It was a very dangerous condition, and it was going to cost, it did cost, well, we thought it was going to cost $20,000, and it cost like $28,000. Put a whole new chimney in a house from underground up, because it was the first, the portal to the first fireplace was actually technically underground. It was a very expensive, long process, and we just renegotiated the price because I really wanted to buy and the seller really wanted to sell. But if we didn't have that inspection, I wouldn't know enough of that was a flaw and that was a problem, and I would have had to have eaten it because the seller usually makes no warranties or that they know of, and the seller, I generally don't think they knew of it. They owned that house. They were the second generation. It was the adult children that was selling their parents' house that they grew up in from the 1950s and 60s. It was kind of a nice story, but they said, we didn't know there's any problem with the chimney. And I believe them. I really do. And we found out a good lesson. Something you can check out, things like that. The boiler might be aged and flawed. The roof might need to be replaced soon. And so you know what you're getting. And so does the bank. The bank often insists that there be some kind of inspection done to make sure the house is, it's got some integrity to it. So it's just a wise move. Then there's an escrow agreement where the down payment, sometimes you have to put like a significant portion down so the buyer knows you, in fact, are serious about going forward with the thing. And that's often acted as litigated damages, meaning that liquidated damages, I should say. The buyer fails to go forward, that escrow money, that deposit will often be forfeited to the seller for failing to go forward without just cause. These are the just cause reasons you put in. This will allow me to get out of the contract. In a title policy, I always urge people when they're buying real estate, always buy title insurance, because even a very well-run title search doesn't always show every potential defect. And there's nothing worse than you're in your dream home now, you have it, and somebody knocks on the door and goes, what are you doing in Grandpa's farm? Get the hell out of here. We've been away for 2 years and we're back to get our farm back. And you say, whoa, we did a title search. Well, maybe there's a flaw in it. If you buy title insurance, and the old saying is the only people that don't need title insurance are the people that have it. Because when you buy it from a title insurance company, they're the ones that usually also do the title search for you initially to warranty valid title. And so they're willing, because they did their due diligence, they're willing to sell you. It usually doesn't cost more than a few $100s. It's a one-time fee. The bank's going to usually dictate you buy a lender's policy of title insurance, and it only costs a couple $100 more to maybe $300 or $400 more for a one-time premium that lasts for you and your heirs to protect from future claims. And it's just money well spent. And I remember it only happened once. My when I did real estate transfers, it only happened once, and I had my client buy title insurance with title rundown, didn't find any problems. And about 3 years later, he was trying to sell it. And the buyer came forward and says, "Hey, Jim, we've got a problem here. There's a title flaw." And there was some mortgage that previously, obviously it was paid, but it was never discharged on the record. And literally all we had to do was call the title insurance company, and they went out and fixed the inherent problem. But if it was about money, if somebody had to be paid the fair market value, they would do it. And it's a very, very how can I say it? Money well spent, really, to buy title insurance. In fact, if you're buying a house with a bank, a lender involved, you're going to have to buy it for them anyways. It's a little bit more money to buy it for yourself too, because once your mortgage is paid off, the bank no longer has an interest in the property, so their title insurance disappears with them. Good cases in the book. Adverse possession, it's just a fun topic. It's not going to come up that much. But in different states, if you openly and hostily, you're not recognizing the true owner's right to property, you're using it in a regular, not necessarily daily, but in a regular course of behavior for a statutory period of years of time, you become those, it's sometimes called squatter's rights. You become the owner of the property. It does not work against the government. So say if government owned real estate near me and I was using a chunk of their land open notoriously as a farmer, and I farmed an acre of government property that was next to me for 20 years, and I did it open and notoriously, basically, not acknowledging the true owner's rights to that property, I will not become owner of that property. But what if I didn't really know my property line? I actually live kind of on a farm property now, and there's some stone walls and things like that. I don't know. And maybe even my neighbor doesn't really know. But for some reason, I've been using maybe 300 yards of a strip of property on their land I always thought was mine. And I farmed it, and I put my horses over there, and I had picnics over there on a regular basis, and maybe I even put some structures over there. In Massachusetts, I believe it's either 20 or 21 years, and I did it open and notoriously. I would actually become the title owner. I'd have to take a court action it's called quiet title action. I'd actually go to court. But if I could prove I adversely possessed that property for the specific number of years in an open and notorious fashion against the true owner's rights, I'd actually become the title owner. It's a very unpopular area of the law, but it's an interesting one, that's for sure. And it's fascinating. I remember many years ago, because the guy's been dead for a long time, Peter Jennings, I believe was his name. He was the ABC what do you call news anchor, and they were talking about a story out of Colorado where I think it was 7 years was the statutory period for adverse possession, and these people were basically farming on some neighbor's farm and it was without permission. If it's with permission, adverse possession, it has to be adversity. You have to be not recognizing the true owner's right, and you have to do it without consent. And that's what these people did. And then they went to court and they quieted title. And they got several acres of their neighbor's property. And it was very shocking. That's why it made the news, because people are surprised by it. You have to understand why the rule exists. At one time, we had this pioneering lifestyle in our country. People were going west and starting up farms and abandoning them, and new people would come in and try to make good use of the property. And we wanted to basically create a system that if somebody uses it in good faith, some jurisdictions require good faith. I don't know what that really, the whole analysis is much bigger. Massachusetts does not. But if you use it openly and notoriously against the true owner's rights for the statutory period, you become the title owner. it's just kind of interesting. I'm not that big in it. Trespassers in Massachusetts, trespassers have to be given notice. That's why people put up signs like no trespassing. Otherwise, the government can't take action against them. You can't be charged with trespassing unless you have actual notice or constructive notice that you shouldn't have been on the property. Not going to worry about that. Oh, condominiums is pretty interesting. Condominiums, that you buy the property, but what you own is the interior walls of the individual units. You own as tenants in common the common areas with the condominium association and the other members of the condominium unit. You have to pay monthly dues to basically share in the ownership of the condominium facility, and that's part of the master deed. If you don't pay those shared duties, you can lose your property to foreclosure to the condominium association. It's basically like owning the interior of your apartment in the common areas or shared ownership with the other people. The only thing I'm not a big fan of condominiums because the exterior of your condominium, you might look at it and say, geez, I'd really like to change this and or put up some flags or something on the outside, or I want to extend the deck that's off my piece of property. You're usually very, very restricted according to the master plan, and you have to get consent to do almost anything through the condominium association. They're responsible for things like roofs, exterior walls, maintenance of fields, and things like that. But you can't, like, I got windows looking out. I'd really like to change these to Andersen windows or Pella windows. But if they're not going to match all the other units, you're probably going to be barred from doing that. So it's a bit of a restrictive way of owning property. Some people don't mind it. Some people love it. My brother would be one that would love it. I'd hate it. It just doesn't feel like true ownership to me because it's like, I share the yard with all these other people, and the outside and exterior walls and the hallways are all shared ownership with other people. And the condominium association has a lot of power, and that's why if anybody's a Seinfeld fan, there's I think several episodes where Jerry Seinfeld's father is constantly in some kind of race about running for condominium association because of the power involved in it. What I thought was funny about it was there's some truth to the nature of what it is to be involved in condominium ownership. Not a big fan, but that's neither here nor there. It's just the legal standards. Non-freehold estate, I'm not worried about that. Oh, landlord and tenant. The landlord has the obligation to allow for what the main thing is: quiet enjoyment, and it has to be habitable. It has to meet minimum standards. If it doesn't, it violates the rights of quiet enjoyment. And obviously, the tenant has to pay. And what those standards are usually related to the health and human safety codes of, like, it has to heat so much in winter, hot water, it's got to be safe, it's got to have, windows that are functioning, doors that work. I don't know all those different codes, but it has to basically be maintained to the standards of the building codes, and a tenant has to pay reasonable fees and costs of the tenancy. If it's an at-will tenancy, that means it's month to month, meaning that the tenant can leave at any time provided they give a full month's notice. And same with the landlord, doesn't have to have any cause. Basically, you're paying your rent, you're a great tenant, you're a wonderful person, but if that landlord wants to rent to their kid or their friend or something like that, as long as they give you the 30-day notice, you have to be out. That's a tenancy at will, month to month. A lease is a longer period of time, and if it's more than 1 year, it has to be in writing, and it should be recorded at the Registry of Deeds to protect you. Then you cannot be evicted unless it's for cause, failure to pay, or you violate some other term. You weren't supposed to have loud music after midnight, and in the contract it says if you're disturbing the other tenants, they have a right to evict you, provided that it's 3 or more instances within a certain time frame, or whatever the conditions say within the landlord tenant. It's a big area law. I always used to joke about the old courthouse being the most miserable place. Family law, I think, is definitely the most miserable place. But in terms of like the atmosphere, I always thought the landlord tenant was the worst, because landlords are very, very embittered by tenants who often aren't paying and maybe causing some degradation to the tenancy. And the tenants are very upset because they think their landlords are, slumlords, and they're renting them some subsistent type living situations, and are not maintaining the property enough to make it really habitable. And these allegations go back and forth, and the housing court has to try to come up with justice. And it's not an easy area to practice in. Plenty of work there, though, by the way. And I always recommend, if you're a landlord or a tenant, to go around at the beginning of the tenancy and take instant photographs. And you take all the different photographs. It's a big crack on the wall. It's not affecting the habitability of it, but you're going to pay a big security deposit potentially for damages. You want to show that that damage pre-exists you owning it as a tenant. So a good landlord and tenant will go out with these instant cameras, and you'll print and you'll put the date of all the things that pre-existed. Like maybe it's a nice apartment, but the old linoleum floor is really worn out in the center area, not such that people would trip on it or be damaged by it or anything like that. But you don't want the landlord coming back to you after you move out in 2 years saying, I'm going to have to keep your security deposit because I have to put down new linoleum because you ruined the old linoleum. Well, you didn't ruin it. It was already in disrepair when you bought it. Not enough to be a violation of the health and human safety codes, but enough where you want to have it documented. And good landlord, you'll both sign the instant pictures. You both keep a copy. And that way, if disputes arise, it can be more easily proven. And that's often what the case is in landlord-tenant, is proving who did the damage and who didn't do the damage and things of that nature. And when it comes to security deposit, Massachusetts has a very strict law, as most states do. Security deposits usually have to be kept in an interest-bearing account with the landlord as trustee for the benefit of the tenant. It has to be interest-bearing, and I believe the tenant has to be given periodic notices of where the money's kept and how much interest it's earning, and it inures to the benefit of the tenant. And that has to be given back to the tenant at the end of the term of tenancy. But obviously the landlord can keep portions or all of it if there's damage to the property, but it needs to be documented. I was thinking about the last time I had an apartment. It wasn't that long ago, maybe 10 years ago, and my kids lived there, and I wouldn't let them put up any posters or anything on the wall because I knew I'd be living there for a year or two until we bought a house. And I used to paint for a living, and so when I was leaving there, I left it way better than when I had found it. And I'll just leave it at that. There's no question about it. And I remember the landlord, who was a nice guy, he seemed like a nice guy, and he wanted to keep half of my security deposit. He said for cleaning and maintenance. I said, it was wait, and then and he goes, and I remember him saying, "Well, I'm not a lawyer," and I said, "Well, he didn't know I was." And I said, "Well, I am." I said, "You can't just get like a windfall from the tenant if the tenant's left you with the same or improved conditions of the apartment before I left, And then because I'm kind of a hothead with stuff like that, I said, you obviously need the money a lot more than I do, so keep the half that you've retained, and just know in the future that if you do it to somebody else, hopefully they'll have a halfway decent attorney, and you'll be subject to not only giving up the money you've kept, but you can get punitive damages here. Landlords get really nailed on this if they don't keep the security deposit in the right fashion in a trust fund account, like I had said, or they don't return it to the tenant without real justification. They're usually subject for triple damages, and it can be very much of a sting to a landlord. Yeah, month-to-month tenancy, year-to-year tenancy, leases, fixtures already talked about. Personal property. Those of you who take business law with me, bailments, that's just somebody possessing somebody else's property. So if I had somebody come in my office and they borrowed my sling-line stapler, they don't own the property. I still have title to it. They're using it for their sole benefit. So it's the sole benefit of the bailee. I'm the bailor, the owner. I'm letting somebody else use it. It should come back in the same condition. But if they're using my staple, I should have expected that some of the staples might be missing from it, obviously. The same, someone borrows my car this weekend. I am the bailor. They're the bailee. If they pay me nothing, they owe a high degree of care while they're possessing that vehicle. But if they're giving me some money to use my vehicle, then it's mutual benefit, and all they owe me is reasonable care. Now, what if I gave it to my friend to go have it repaired, and they're going to do it for free out of the goodness of their heart? They're going to take my car for the weekend. Now it's for the sole benefit of me, the bailor. They only owe slight care, and they'll only be responsible if they're grossly negligent. I don't want to get too big into it. Abandoned property versus lost property. If abandoned property is truly abandoned, the true owner of it has relinquished any kind of ownership. Abandoned property, I bring my trash to the curb, whatever's in there, I obviously have no intent to retain any kind of ownership or title to. That's abandoned. Lost is different. I'm swinging around and my wedding band goes flying off. I didn't intend to abandon the property. It's mislaid. I remain the true owner, but if anybody that possesses it, they have a right to possess it until the true owner can be identified. And there's rules about how you can file things with the police department. They hold it for a certain period of time, then you're entitled to possess it. However, if the true owner comes forward for all eternity, believe it or not, that true owner has a right to get retained because they never gave up title. Value, intellectual property, don't even test on conversion, trespass, chat, reprimand. I'm not even worried about that. Well, constructive eviction. Constructive eviction, the landlords just make it really impossible to enjoy your apartment. So therefore, it's as if you got evicted, even though they didn't go through a legal process. So therefore, the tenant has an argument they shouldn't have to pay outstanding rent under the lease because they've been constructively evicted. The landlords made it basically hell for them to live there. Mutual benefit, yeah, gratuitous benefit, non-freehold estates. Yeah, I think that's pretty much warranty of habitability is the warranty that the property will be safe from human occupation. It's really that simple. I went really long. It's a long chapter. It's an important chapter, but again, it's going to be filled in, I think, much deeper if you get into either real estate and somewhat a little bit in family law, and if you take a business law class, maybe we go over these same topics again and again and again. The best way to learn real estate, to get out there and practice, doesn't take a heck of a lot to become a licensed sales agent. It becomes a little bit more to be a broker, but if you do a little work in the area, you learn quite quickly, and it can be a lucrative way to make an income. I dabble in it myself. I'm a broker. My sister's an agent, and sometimes we work together on real estate transactions from time to time. But not as my sister has a main career. I do it just as more of a buyer's agent. So I know that looking for property, I'll help them find one, and the seller pays me a small commission for doing it. And when you get involved in those things, you start learning all the how to dot the i's and cross the t to make sure the transaction goes smoothly. Because the seller wants to sell and the buyer wants to buy. We just want to make sure everyone knows what they're getting into, and that's the due diligence and writing everything out so there's avoiding of any confusion or misunderstanding as you go forward. Otherwise, that's it for chapter 12. Well.